Hi, I am family law attorney Amy Dohrendorf. An issue that must be addressed in all dissolution of marriage cases is the division of community property. Arizona is a community property state, which means any and all property acquired by either spouse during the marriage is subject to equitable division in the divorce proceedings. However, there are exceptions to this general rule. Those exceptions include property acquired by gift or inheritance, property acquired prior to the marriage, and property acquired after the service of the petition for dissolution of marriage or legal separation. Community property law applies to even those situations where property is titled or held in only one party's name if that property was acquired during the marriage. In general, community property is divided equally between the spouses, as they both have an undivided one-half interest in the community. If not an exact 50-50 division, then community property must be divided fairly and equitably depending upon the circumstances. If your matter proceeds to trial, the judge has considerable discretion on the division and distribution of community assets. The division depends on the kind and nature of the property and what is fair distribution for the divorcing couple. However, in many cases, the parties agree as to the characterization of the property and utilize mutually agreed upon values for their property. For instance, when it comes to vehicles, most parties agree to utilize Kelley Blue Book values. In regard to personal property, parties understand that personal property is not valued by what it would cost to replace these items, but rather how much they could receive for personal property if sold at a garage sale, on eBay, or Craigslist. As it relates to real property, parties often agree to utilize the appraised value if one party is keeping the real property. Bank accounts, retirement accounts, and pension plans are valued from the date of the marriage through the date of service of the petition for dissolution of marriage or legal separation. If the parties agree to selling property, the value is what the market brings, and the profits from such are generally split equally. The equitable division of community property becomes more complicated in situations where there is a dispute as to whether or not the property was gifted or inherited, or if community funds were applied towards sole and separate property. Generally, property is characterized as separate or community property at the time it is acquired. If you own property prior to marriage, the characterization of that property is not altered by marriage. However, when community funds are used to pay a mortgage, loan, or used to make improvements to the separate real property owned by one spouse, the non-owing spouse has a community lien on the other spouse's separate property. When a spouse commingles or mixes his or her separate property in with marital property, it may be transmuted into community property. Many couples have some transmuted property to consider in their property division. If yours is a high-asset divorce case, then it is very likely that some litigation may be involved to determine the character and value of certain assets. To establish asset valuation in complex cases, we use qualified experts such as forensic accountants, business valuators, personal property appraisers, real estate appraisers, and realty agents. The division of community property is at the forefront of your divorce settlement. As you can tell by this discussion, the division of community property is not as cut and dry as some might think. It is that very reason why you should hire an attorney who understands the principles of community property and can obtain for you what you are legally entitled to receive. If you believe you are one of the many who may have a more complex community property division, I strongly urge you to obtain as much documenting evidence as possible regarding the characterization of the property in dispute. This involves gathering settlement documents from the purchase or sale of real property, titles, deeds, wills, prenuptial agreements, receipts, and financial account statements. The relevant time period for most property that falls within this questionable range is immediately before the date of marriage and as close to the date of service as possible. These documents will assist your lawyer in obtaining a just and equitable result in your family law matter.